Hello everyone. So in this video we are going to talk about the special intensive revision as it is happening in Bihar. Let us try to look into various legal provisions under the constitution as also the law and the rules under which this exercise is happening. So this will make it clear and it will help us also to analyze as to about the legitimacy of the exercise overall, and also we know that a lot of controversies have got generated with respect to the manner and the process in which it has happened and the response of the election commission, the way it has organized its press conference and other things. So let us first try to understand that what constitutional provisions are there with respect to the preparation of electoral rolls. So this is largely an exercise of revision of the electoral roll. So according to a law of the parliament, that is Representation of People's Act of 1950, we have been provided with these provisions. So first and foremost, let us just see that in the constitution, what are the provisions given? Article 324 of the constitution, it talks about the power of the election commission overall to conduct election and also preparation of electoral rolls. Now this is said to be a powerhouse, a provision which is a powerhouse for the election commission. In a number of cases, Supreme Court has also called this as the basically a repository of plenary powers, means unlimited powers of the election commission. So here in the election commission, it will take care of the superintendent's direction and control over the entire process of election, and more specifically those in relation to the preparation of electoral rolls and the conduct of elections. So this has been given as far as the power of election commission is concerned. Then article 327 of the constitution, it talks about that the parliament will have the power to make law with respect to elections and various aspects of elections, which will include the preparation of electoral rolls as also delimitation of constituency and thereafter the conduct of elections. So it is under this provision, that 327, which talks about the preparation of electoral roll, also the Parliament has made a law which is called as the Representation of People's Act 1950, which everyone knows. Another law has been made under this Representation of People's Act of 1951, which is related to the conduct of election. So 1950 law is related with the preparation of rolls and delimitation of constituency, everything which could be called as a pre-election exercise. And the 51 Act, it is about the conduct of elections thereafter in detail. So in this Representation of People's Act of 1950, there is a provision under section 21 which talks about the preparation and revision of electoral roll. Also under section 15 of the Representation of People's Act of 1950, we have a provision that every constituency should have an electoral roll which needs to be prepared in a prescribed manner as per the requirement of the law, and that it would come into effect thereafter. So under 21 there will be preparation of and revision of electoral roll. Under this we have section 21 clause 1, which is we are going to discuss about clause 2 over here, but before that, under section 21 clause 1, it talks about the preparation of the electoral roll, which will happen according to the prescribed manner and with reference to the qualifying date. That means Election Commission is going to come up with a reference date, which is generally the 1st of January or the 1st of April or the 1st of July or the 1st of October. So these dates generally are considered to be the reference dates by the Election Commission, depending upon when it is doing the revision, when the elections are being organized. And at those dates, those people who have attained the age of 18 years, they become eligible to be registered as voters. So in reference to those qualifying date, the section 21(1) talks about the preparation of electoral roll in a prescribed manner, right, as per the requirement of this law, that is Representation of People's Act. But section 21 clause 2, it talks about the revision, and here we are interested in that revision should happen in the prescribed manner by reference to the qualifying date. Again the same thing, that whenever the revision is happening, Election Commission will notify the qualifying date, and on which the date the electors who have turned 18 years of age, they will become eligible. So we say revised in prescribed manner, that is 21(2). And this, whenever it is going to be revised, when it is going to be revised, this is happening before every general election for the Lok Sabha as well as the State Legislative Assembly, before every by-elections whenever it is to happen, and in any year as directed by the Election Commission. Apart from this, also at any other time Election Commission may announce. Now this generally happens to be a routine exercise. That means this is like an update of the electoral roll before the elections. Now a little more detail about this exercise would be given in the rules which have been made under the Representation of Peoples Act 1950. This we are talking about the provision in this law itself, that is section 21. So section 22 is clear, this will be more or less a routine exercise. Apart from this, there is another section 21 clause 3 which talks about the conduct of a special revision. So here we have, this is the section where we have the provision for a special revision. It says that Election Commission at any time, for reasons to be recorded, the reasons need to be recorded, and it can direct a special revision. Now one more thing that is mentioned, that this special revision, whenever it is to happen, it has to happen for any constituency or a part of a constituency. That means the notification should be constituency wise, but then maybe for a number of constituency also there's a possibility that notification can come. So a special revision can be exercised constituency wise, and you see it's mentioned reasons to be recorded. Now the question is that should reasons be recorded every constituency wise, or can we say that for the entire state the revision is going to happen and the same reasons can be recorded for all the constituency in the state? This also becomes possible as per these provisions, right? So it's just a matter of interpretation. Thereafter, a rule which is made under representation of, to just get into a little more detail about the provisions, there are rules which have been made. So first we have the Constitution, that is Article 327, and then the Representation of Peoples Act of 1950, and under Representation of Peoples Act of 1950 we have rules made, and these rules which have been made under this act, it is called as Registration of Electoral Rules of 1960. So we will now get into these rules and see some of the provisions which are there in the rules, specifically rule number 25. Now we are interested in this rule number 25, which talks about, which says that rule 25 says, the clause 1 of this rule, it says that the rolls can be revised under section 21(2). That means the routine revision, right? 21(2) is routine revision, which section 21(2) is of the act which we just discussed. So routine revision can happen, 21(3) special revision can happen. So rolls can be revised under section 21(2). Whenever this revision will happen, this revision will either be intensive revision. So the routine revision can also be intensive revision, or it can just be a revised summarily, that is a summary revision. A summary revision is something which is for the updates and which is a routine exercise which happens almost every year. Over the period of time, we have seen the trend that Election Commission have of late been doing more of summary revisions than intensive revisions. This is because in the initial years the voter list it had not settled, and the process also had not settled. There had been many other factors and some volatility in our socio-political different aspects were there, because of which the Election Commission had resorted to frequent intensive revision of the electoral rolls in the earlier years. But in the past 20 years, as things have settled, Election Commission, and also because a lot of laws have been made, the entire process of election is better regulated, so Election Commission has not been resorting to intensive revision. Mostly it had been doing the summary revision. There is a provision under the rule that this routine exercise which happens under our section 21(2), this can also be a mix of both intensive and summary revision. So it can be partly both as well. So these are the possibility. Then it says that the clause 2 says that whenever there is intensive revision, whenever there will be intensive revision for section 21(2) or for any other reason, because here the reference of 21(2) is not there. So any kind of intensive revision which may be part of special intensive or which may be the routine intensive, whenever there is intensive revision, it has to be prepared afresh. Now this is the provision where there is a problem. The problem is that the Election Commission in these special intensive revision, it says that whenever any kind of intensive revision will happen, the preparation will be afresh. Now this is one clause where legally Election Commission could be challenged also, though of course it becomes difficult to prepare everything all afresh, and you can just consider electoral roll of a particular year to be a base year, and on that you can build upon. But this is not going to be the completely a fresh exercise, as perhaps is expected by clause 2 of rule 25 of the representation of the registration of electoral rule 1960. So here we expect that the intensive revision, whenever it will happen, it has to happen afresh. This is not the case with respect to what's happening in Bihar. We will find it out a little more detail about it a little later. So overall the issue is that the special revisions as election commission, then also you see here, as we had talked about in the previous slide, I mean before this, when we talked about the special revision, special revision can happen whenever election commission thinks fit. So special revision can happen at any time, and as election commission thinks fit means whenever it wants to and in the manner it wants to. So special revision can also be intensive revision, it can also be a summary revision, right? So routine revision or special revision, both of them could be summary or it could be intensive. Routine one can be summary or it can be intensive, is very clearly written there. For a special revision, there is a provision and it is written that as election commission thinks fit, so it can be intensive special revision also. So there is a possibility of this happening. And then whenever the special revision is happening, it says it only constituency wise or its part, it will go into it, or the reasons have to be recorded. So every constituency could be the entire state also, it depends, but then still things could be questioned over here in case of special revision. And then the intensive revision, it says whenever intensive revision will happen, it has to be afresh. So these are the three points which we have just picked up from all the provisions which are given there, that special intensive revision as election commission thinks fit, it is possible. Special revision is only constituency wise, this is given there, but then maybe it could be interpreted overall state wise also and collect all the constituency overall. And the intensive revision, it has to be afresh. This is the one on which a question can be raised. Now, if we talk about the one or the process exercise which is happening in Bihar, 24th of June, Election Commission, it had come up with this announcement, and it also came up with a notification thereafter, wherein it says that the aim of the SIR, that is special intensive revision in Bihar, or maybe it is starting up with Bihar, or maybe they have to conduct for the entire country as it has been said. So aims to maintain the integrity of the electoral roll. Of course, I mean the Election Commission will always talk in these terms, and it is aims. What is the aim? Aim of the SIR is to achieve this, that no one is excluded from the electoral roll, that no one who is not eligible remains on the roll, and of course if there are deceased people or the people who have shifted or absentees, their name should be removed. So this exercise will have this objective which Election Commission has mentioned, but then whenever it is getting into special intensive revision, the reasons have to be recorded, though it is expected constituency wise, but obviously in this case it has been given state wise. So Election Commission has justified this exercise. Why? It says about the rapid urbanization which has happened in the recent times, but then the question is, was rapid urbanization not happening earlier? And perhaps that was the reason that at different intervals the special intensive revisions have been organized. Frequent migrations have been happening, addition of newly eligible young voters, underreporting of deaths, and the inclusion of names of foreign, we have already many foreign illegal migrants, their names have been included. So all these factors put together, these are probably the reasons which have been, but these are very general reasons. These are very, very general reasons. Election Commission has fixed up, let's see further, just keep these reasons in mind. Election Commission, what it has also done, it has established the qualifying date of 1st July 2025. This means that everyone who becomes 18 years of age by 1st July 2025, this is that date I was talking about, a reference to a qualifying date. So 18 years of age, anyone who's reaching 18 years on 1st July will become eligible to be voter. And there's a cutoff date of 1st January 2003. What does this mean? This means that 2003 is the base year. So everyone who were in the electoral roll of 2003, they would automatically be included in the new roll. So the only proof they required to give is that their names have to be in the electoral roll which got published on 1st January 2003 in Bihar. So if their name is there in this electoral roll, they automatically will be there in the new roll, and they do not have to give any documents. The only proof is the electoral roll of 1st January 2003. That's it. This is where there may be a problem, in the sense that when you are conducting an intensive revision, it is expected that it has to be a fresh exercise, which this doesn't turn out to be. At the same time, we have to look into the feasibility of conduct of such exercise also, where the Election Commission can give this reason also, that it is in such a vast set of population, it becomes difficult to conduct all afresh electoral roll registration within a stipulated or limited period of time. So that could be an argument which may be accepted also, you never know, but certainly there are questions over here. So this, and then again, why they are deciding on this particular cutoff date itself, as many such litigations which have been filed, especially that of the Association for Democratic Reforms ADR, they say that there is no intelligible differentia as far as this date is concerned. That means why this classification has been, why this particular date has been taken, why before that and why after this. How does it differentiate? What is the intelligibility? There is no basis, no explanation has been given as per this date. Probably the only reason which the Election Commission has is that the last time the special intensive revision which has happened there in Bihar was in this particular year. So thereafter, if it is conducting, so it can conduct this to be a cutoff date. But still, these doesn't seem to be a solid reasons to be recorded. I mean, there has to be some kind of reasons which to be given, the necessity or the urgency of conducting such an exercise, that actually is probably not justifying it overall. But yes, on the other hand, there could be, I mean, generally if you look at after this much of interval of, I mean, of 20 years, maybe Election Commission would like to conduct such an exercise. That becomes possible. So we say with this, I have already mentioned, those who are registered in electoral roll on 1st January 2003 need not provide any documents, right? And after that, people have to provide documents. They have come up with a list of 12 documents. I mean, we know that the ration card, voter ID, and also the Aadhaar card is not acceptable. Now, this has become a big issue. Recently, Supreme Court has advised the Election Commission, it has not directed, has advised the Election Commission that it should accept these documents as well. But then, of course, by this time, almost the exercise is almost over and a draft roll has already been published. So those registered later need to provide documents. Okay, now let us look at the process. What process was followed in this? What was given? I mean, how this intensive revision happens. So here we have the Election Commission delegating its powers to the booth level officers. Booth level officers will have the responsibility of doing a door-to-door survey. In this survey, they will identify the eligible and ineligible voters. For this, you need to train a large number of booth level officers. That itself was a very, important point, that whether in such a, period of time of like 4 or 5 months, or maybe even less than that, like 1 or 2 months, would they be able to train all these BLOs to the required levels, because the BLOs, they have been found to be exercising their discretion also on the ground. And on the other hand, there's some role given to the EROs also. EROs are electoral registration officer, which are again appointed in the Representation of Peoples Act of 1950. EROs, they have the prime responsibility for the registration of the voters and preparation of electoral rolls. They require to print a pre-filled enumeration form for existing electors, and this will be given to the BLO. BLO will take these forms. Those who are already electors, they can easily fill up their information and give the documents. Obviously, if they were not there in the electoral roll of 2003, and rest of them, they will have to fill up further more details. BLOs will distribute the enumeration forms and collect them back from the voters and also their documents. Alternatively, the electors, they could also fill the form. They can download it from the Election Commission's website and then upload it also. I mean, basically from the local officers, their websites, they can upload the form over there also. So this is an alternative to the electors. They could fill form and upload the form along with their document, or maybe BLOs, they can give it to BLOs. Now after this, once the document and these information or the enumeration form have been uploaded, the Election Commission also invites the political parties to participate in this booth level, through their booth level agents, in this entire exercise, and to report if there are misgivings anywhere. And also they can question certain things, or maybe some objections or claims may be there with respect to the preparation of electoral roll. So then if there is any complaint by the voters, electors, by the political parties, their agents and so on, they will register their complaint with the assistant EROs with respect to the manner in which this exercise has been taken up. And thereafter there will be hearing, of course, and the final publication of the roll will take place. So this is just a brief process of how the electoral roll, it has been prepared in this special intensive revision exercise. Now there are certain problems and challenges, like few of them I have already mentioned earlier. Let's like highlight all the issues and challenges. Many of them have been highlighted in the petitions which have been filed in the Supreme Court. Some have come across through the political parties and so on. So we have it says that no clear provision for special intensive revision as such, but yes, there can be derived provision. As I've told you, there can be a special revision, and special revision, because Election Commission thinks fit the manner in which it can happen, it could be intensive exercise also. So there is no clear cut one single provision in the laws or even in the rules, but still it could be derived. Special revision only constituency wise or its part, this is mentioned. So then again there's a question, will it be only constituency wise? Will the reasons need to be recorded only constituency wise, or collectively for the entire state also given? But then practically it should be there that it should be given state-wise, otherwise it will become very difficult for the Election Commission to conduct such an exercise. Then not taken up as a fresh exercise. This is an important point. This is where criticism can come. This is where questions can be put legally also, because the entire process of revision, when it is happening in the intensive mode, it has to be afresh, as it is very clearly and categorically mentioned. Now this is not happening. So this is one area which can be challenged. In fact, this has not been highlighted as much in various debates also and in the litigation also, but this is an important point. Then recorded reasons, as we say, this is alleged, this is being said and criticized that the recorded reasons, they are not convincing. Yeah, because they seem to be pretty generic, and this is something which is happening all the way, almost, as throughout this period this is happening. So why now? That's the question. Shift of burden of proof is on the individuals. Now this is a yes, because the entire process, because the kind of documents which the Election Commission is asking for, it seems as if it is becoming an exercise of rejecting the voters, that, or maybe it is becoming an exercise of figuring out the citizenship of people or something. So that's why it's not a very inclusive approach, and the shift of burden has been there now on the individuals, that they will have to provide for the documents. So their active role is required. The very short time frame in which this entire exercise is happening. So if you have in a short time frame this is happening, then the electors or the voters who are to register themselves, they will not have much time to claim or to appeal also. Now one more thing I just wanted to clear here is that once you have the electoral rolls have been finalized, well, that is once the assistant ERO has sorted out the disputes and other things and the roll has been finalized, thereafter there can be statutory appeal also. Under the law, under the Representation of People's Act 1950, there is a provision that the registration or the rolls, it can be challenged to a local authority, first to the DM within 15 days, and thereafter another appeal could go to the Chief Electoral Officer, who is an officer at the state level, within 30 days. So this itself will require at least 1.5 month of time should be given for the possibility of any statutory appeal to be there. Now this argument was also placed by Mr. Yugendra Yadev in the court, that if the exercise is limited to this much period of time, there will not be enough time left for the people to go for statutory appeal. That's one criticism. Then no prior consultation was done when this exercise was taken up with the political parties or with other stakeholders, as should have been by the Election Commission. Maybe a brief consultation process should have been there. Cut-off date of 1st January 2003 lacks intelligible differentiate. I have also already mentioned required training of 1 lakh booth level agents within a short period of time. Whether they have been trained to those levels by which they will be able to actually do all this registration process properly or not. It is becoming a process of identifying citizenship, as I mentioned. Procedural lapses have been there, where BLOs have been found to be exercising a lot of discretion, and their whims, they have been probably registering the voters, and not much time for statutory appeal. These are the criticism. We have just focused a little bit more on criticism because that's how the entire process is looked into. But as far as the legal provisions are concerned, there are provisions. The only place where it can be questioned is that special intensive or any kind of intensive revision needs to be a fresh exercise. That is the problem with this entire process. And then of course the ADR has challenged this on these very basis itself. Many of these points have been taken up from the ADR's petition itself, and the Supreme Court has come up with, in this interim directions have been given by the Supreme Court on the 5th day of the hearing. So it says that the challenge was that overall process seems to be arbitrary exercise and violative of the universal adult franchise. Supreme Court has given these directions. Now we already know these quite well, that the Election Commission needs to publish the DEO, that is at the district level in the website. It has to publish the 60 lakh voters, name of these voters who have been deleted, because once the draft electoral roll was published, around 65 lakh voters, their names have been removed. So if their names have been removed, the reasons need to be given and the entire list has to be published as to who were these voters. Election Commission needs to publish this. This is a direction of the court which the Election Commission has already published by now. Information should also be given district wise and booth wise about these people, and it should be searchable through their photo identity card number as well. Reasons for non-inclusion should also be mentioned, and the physical display of the list should be there at the BDO offices and the Panchayat offices as well. So these are the directions of the Supreme Court regarding this, and the list to be widely publicized as well. So now these rolls are out and it has been published, and maybe more questions are being put, but somehow the entire process, there are a couple of questions which need to be answered, and perhaps Election Commission didn't seem to be in the right mode to answer these questions, though the Election Commission should have taken the responsibility and it should have clearly answered and removed any kind of apprehensions which are there in the minds of the political parties or their representatives. This is where we see that the overall the conduct of the Election Commission itself, it has been questioned by many people, and there have been allegations also leveled up against the Chief Election Commissioner in terms of the way the press conference was conducted. So that's all what I have to discuss as part of this video. Thank you so much.